Hello, and welcome to today's webinar. My name is Jen Rounds, and I'm a senior fellow with the Center for Innovation and Worker Organization, also known as CWO, a think and do tank at Rutgers University. For almost 3 years now, CWO and the Center for Law and Social Policy, or CLASP, have partnered to host a webinar series that convenes labor standards enforcement agencies and advocates working in the field. Our goal for this series is to provide a space for all of us to come together to think through and share promising practices, innovations, and lessons learned, and to maintain a community of sharing and practice. Today's webinar will provide a year-end review of the progress and challenges seen across the country for paid sick leave laws and their implementation, and you will hear from local agency leaders on the strategies they employ to best use their limited resources and overcome common challenges in paid sick leave enforcement. So on behalf of CLASP and CWO, thank you all so much for joining us today. I'm going to turn it over to my partner, Tanya Goldman from CLASP.
Thanks, Jen. And hi, everyone. My name is Tanya Goldman, as Jen just mentioned, and I'm part of the job quality team here at CLASP. I also want to thank you all for joining us for our final webinar of 2019, and thank you, Jen, for all of your partnership. Quick logistics note before we get started. Please submit questions at any time through the GoToWebinar chat feature, which you can find on the right side of your screen. And we will ask these questions at the end during the Q&A, but you can feel free to submit them at any point. So according to BLS data, we know that almost 30% of private sector workers in the U.S. do not have access to even a single paid sick day. We all know that a lack of sick days can lead to health consequences, lost jobs, and poverty, and that the gaps in access are most acute for workers in low-wage jobs and sectors. That's why we're so particularly grateful for all of you on this webinar for the work that you do. First, to pass these paid sick days laws, and then to make sure that the laws are implemented and enforced equitably so that all workers know about and benefit from them. We also know that this work is really challenging, so we're thrilled to have 3 experts on the call today to present to you as we take stock and look forward into 2020. First, we have Alex Baptiste, Policy Counsel at the National Partnership for Women and Families. Next, Greg Assay is going to speak. He's the Deputy Director at the San Francisco Office of Labor Standards Enforcement. And finally, last but not least, Benjamin Holt, Deputy Commissioner for the Office of Labor Policy Standards at the New York City Department of Consumer and Worker Protection. Thank you so much, Alex, Greg, and Ben, for presenting today, and to all of you for joining us. And now I'll turn it over to Alex.
Great. Hello, everyone. Thank you so much for being here with us today, and thank you to CLASP and Rutgers for putting together this great webinar. As Tanya said, my name is Alex Baptiste, and I am Policy Counsel on the Economic Justice team at the National Partnership for Women and Families. The National Partnership is a nonprofit, nonpartisan advocacy and policy organization based in Washington, D.C. And since our founding in 1971 as the Women's Legal Defense Fund, we've been working to advance policies that help women and men balance the demands of work and family and ultimately achieve equality. And advancing paid sick days is very much a part of that work. So we can go to the next slide. So this is a very quick overview of what I will be discussing today. We'll take a look at the 2019 litigation landscape, noting the wins, which are always very exciting, but also some of the legal woes that other jurisdictions are experiencing, particularly in Texas. And then we'll also take a look at the major trend that we saw in 2019, the rise of PTO laws and proposals, and then discuss some trends that we anticipate seeing as we look toward 2020. You can go to the next slide. So I think for anyone following the paid sick days litigation landscape this year, probably the most notable win came from the Pennsylvania Supreme Court, which was exciting as Pennsylvania is my home state, and that was regarding the Pittsburgh paid sick days law. So Pittsburgh passed their paid sick days ordinance back in 2015, 4 years ago, and anticipated it going into effect in January of 2016. Unfortunately, the Pennsylvania Restaurant and Lodging Association and some other business interest groups filed a lawsuit alleging that the paid sick days ordinance was precluded or preempted by the business exclusion of Pennsylvania's Home Rule Charter. The Home Rule Charter very quickly just limits local actions that burdens employers. So Both the trial court and the Commonwealth Court ruled in favor of the association and prevented the law from going, or the ordinance from going into effect. The litigation lasted 3 very long years, but back in July, the Pennsylvania Supreme Court upheld the ordinance and Pittsburgh finally got their win. So approximately 50,000 workers will finally have access to guaranteed paid sick days, which is incredibly exciting and most definitely at the hands of the people who worked tirelessly to defend the ordinance. Another major litigation win came out of Washington State, so all the way on the other side of the country. Earlier this year, a Washington Federal District Court rejected a preemption and constitutionality claim made by the Air Transport Association of America. The association claims that the Washington Paid Sick Leave Act, as it applied to flight crew and ground crew, was unconstitutional and preempted by the Federal Airline Deregulation Act. They also claimed that the law violated the Dormant Commerce Clause, which limits state and local government's ability to unreasonably burden interstate commerce. But the district court concluded that the state's authority to regulate the workers' benefits trumps the airline industry's fears of interference with its interstate commerce and dismissed their motion for summary judgment, which was very exciting. Unfortunately, that same airline association, in this case, also challenged Massachusetts' paid sick time law on the same grounds, again, that it was unconstitutional and preempted by federal law. And we have not yet gotten a conclusion out of the Massachusetts case, but the Washington decision is definitely a win. So we will be keeping a very close eye on further activity in 2020. So we can go to the next slide, please. So almost in kind of a perfect dovetail from the Washington litigation when the preemption argument certainly continued pretty much across the country this year. First in New York City, American Airlines sued the New York City Department of Consumer Affairs after the department cited the airline for violations of its sick and safe leave law. The department alleged that the airline's practice of assigning disciplinary points for each sick day that was used by a ground crew worker constituted retaliation under the New York City Paid Sick Days law. But then, in response, the airline sued the department, alleging similar claims to those made in the Washington and Massachusetts case. That the New York City law is preempted by the Federal Airline Deregulation Act and therefore doesn't apply to the airlines. So we will continue to see what happens there. But then finally in Texas is where we've seen arguably, or inarguably, the most preemption litigation. And this goes back to 2018 in Austin, Texas. So after Austin passed its paid sick leave ordinance, a lawsuit was very quickly filed by business organizations claiming that the ordinance violated and was preempted by the Texas Minimum Wage Act. After the lawsuit was filed, the ordinance was ultimately enjoined and blocked from going into effect. And unfortunately, that lawsuit has kind of followed each subsequent paid sick days win within the state of Texas. Dallas passed their paid sick days ordinance not long after Austin, and earlier this year, a lawsuit was filed on the same grounds to block the Dallas ordinance from going into effect. And then the same thing happened in San Antonio, also in the same month as Dallas in July of 2019, where businesses filed a lawsuit to block the implementation of the paid sick leave ordinance. Unfortunately, this was after the San Antonio City Council tried really hard to work with business organizations to make some changes and amendments to the law that would have both sides happy and allowed to continue to move forward. But unfortunately, as of right now, where it stands, all 3 paid sick days ordinances in Texas have been blocked from going into effect. So we will have to wait and see what the Texas Supreme Court says in the Austin case to see how that will affect things in Dallas and in San Antonio. So we can move to our next slide. So So in terms of trends that we saw, we're shifting gears a little bit to look at the trends that we saw in 2019. The most notable was the prevalence of PTO, or paid time off laws, taking the place of paid sick and safe days laws. We saw a little bit of this in 2018 in Michigan after the original paid sick days ballot was taken up by the legislature, passed, and then greatly amended during the lame duck session into a law that was extremely far from its original purpose and definitely resembled more of a PTO law than a paid sick days law. And then this year in 2019, we had 4 jurisdictions pass or propose a PTO time rather than paid sick days. And obviously, I think a lot of the momentum behind this trend is the result of politics, which is unsurprising. As most people know, compromises generally have to be made as the bill tries to make its way through the legislative process, and sometimes those compromises don't always result in the originally intended product. So the most prominent example of this was in the state of Maine. The original bill introduced by Senator Kaiser was a really strong paid sick days bill that I think at the time, if it had passed as it was originally intended, would have provided a really great number of sick days and would have had a really broad family definition. But as the process progressed, however, the bill changed to reflect some different priorities of different folks getting involved. The governor of Maine really wanted to get involved in the crafting of the bill, and ultimately it resulted in the country's first mandatory paid time off law, rather than the paid sick time law that was originally introduced. So some months after Maine passed their PTO law, we saw a similar process take place in Nevada. Again, the campaign presented an incredibly strong bill that would have provided, I think, about 10 paid sick days, which would have been the most number of days of any law in the country. And it included a really broad range of family members included in the family definition. But unfortunately, despite working incredibly hard to maintain the integrity of the bill and also having a trifecta, so having a Democratic governor and a Democratic majority in the Assembly and the Senate, the final result was ultimately a PTO law that actually has an incredibly high employer threshold and very little in the way of retaliation protection for workers. In this case, it was really just a lot of pushback from business lobby and a lot of, quote, what they call shaky Dems, who weren't completely comfortable with the paid sick days initiative. And then we ultimately ended up with their PTO law, which will go into effect on January 1, 2020. We also saw a similar chain of events take place in Bernalillo County, New Mexico. So just like in Maine and Nevada, the original ordinance was a strong paid sick leave proposal that, unfortunately, due to last-minute amendments, resulted in changing the ordinance from paid health or paid sick time to paid time off. And then finally, earlier this year, we saw Mayor Bill de Blasio of New York City introduce a proposal to require private employers with 5 or more employees to offer 10 days of paid personal time. So as I've mentioned before, New York City already has a paid sick days law, and this law would amend the paid sick leave law to add paid time off or paid vacation. It wouldn't diminish the current paid sick days law. It would simply add an additional bucket of time, with the caveat that the paid vacation could be used for sick time, and then you can correct me if I'm wrong on any of that. But it just adds to the trend of seeing PTO very much be brought up kind of as an alternative to paid sick days, which may not always be the best bet for workers. So we can move to our next slide. So moving on from the trends that we saw in 2019, that obviously informs us a lot in terms of what we can anticipate, or what we think we can anticipate in 2020, as much as we can look into the future. And then when we're thinking about trends to anticipate in 2020, I think it's fair to say that PTO laws kind of rise to the top here. With 3 PTO laws passing in 2019, 2 of them in states, it's probably very likely that we'll keep seeing this alternative to paid sick days continue. And I think that's for a number of reasons. I think the first is that Many folks probably don't think that workers need different buckets for time off or vacation or to deal with an illness, and that combining all the time together is kind of the path to least resistance. And we know that that's very much the mantra of a lot of business lobby organizations and groups. And I think, especially with what we've seen in Maine and Nevada, that argument also tends to garner a lot of bipartisan support as well. And I think also it's just PTO in general is a bit easier for folks to kind of wrap their head around because they don't need to understand the nuances of paid sick leave and why that specific bucket of time is so incredibly important for workers. And I think for those reasons, it's likely that we'll continue to see these laws, emerge across the country next year. So we'll definitely be keeping an eye on the different campaigns and seeing how each bill progresses. And then kind of in step with the PTO laws, we also saw a trend in the expansion of provisions and uses for paid sick time laws. The first trend that I would highlight we're all really excited about is the continued inclusion of a really broad family definition. The bills that were introduced during the 2019 legislative session, the vast majority of them included the family language that states that the accrued time can be used for any person related by blood or affinity. This language has basically become something of an industry standard for paid sick and faith-based laws, which is really encouraging because it means that workers are able to move, look further than just their nuclear family and take that accrued time for people that they know and that they love and be able to support their family in the best ways possible. We've also seen new uses for accrued sick time in a lot of these laws. So Illinois' bill proposed allowing sick time to be used for court appearances, which is, I think, a new use and one that we hope to continue seeing in the future. We've also seen jurisdictions allow for accrued time to be used in the event of public health emergencies, such as the closure of a person's place of business or a child's school, and also for parents to attend parent-teacher conferences. And that's especially important and sometimes has been highlighted in different bill language. It's for those parents with children who have special needs that need to be addressed with the school and their support staff. So altogether, these trends are sure to make for a very interesting 2020 legislative session, and we're definitely excited to see what the different campaigns have in store as we look forward to 2020 and to a new legislative session. We can go to the next slide is just my contact information and places where you can learn more about paid sick days and the work that the National Partnership does. It also has my email address in case anybody has questions after the webinar. And I guess we'll do questions a little bit later, but that is what I have for us today.
Great. Thanks so much, Alex. And we had a few, because we have so many experts on the call, we have a few additional notes people wanted to share. One from Dallas, that the ordinance is still in effect, and also that they're enforcing the anti-retaliation provision currently. And there was another one about, Pittsburgh is about saying that the act was upheld in July, but the city still has not implemented a note about that. And then we'll save some of the other questions for a little later and turn it over right now to Greg.
All right, thank you very much. I guess we'll go next slide, please. All right, so that's me. So I'm going to provide a quick timeline of our paid sick leave ordinance, as well as talk about what's working and what are some of the challenges that we're facing. So next slide, please. All right, so we'll start with the timeline. Ours was the first paid sick leave ordinance in the country, and I want to acknowledge one of our community partners, Young Workers United, that spearheaded the effort to get it onto the ballot. San Francisco voters adopted the law in November 2006, and it took effect 90 days later. I can say, having been here at the time, that it was a mad rush, not only to publicize the law, but also to develop guidance on issues that were not addressed in the law. We immediately started getting flooded with calls from employers asking questions such as, how much notice must an employee provide before using sick leave, and when can an employer require a doctor's note, and many, many more questions on top of that. So it was challenging without other models to look to, but ultimately I think we did a pretty good job addressing those issues in our rulemaking. Fast forward to July 2015, when California's version took effect. So Alex mentioned previously preemption issues in other states. It's important to know that when the state adopted its sick leave law, it did not preempt San Francisco's law, but it did differ in some significant ways. So in 2016, San Francisco voters amended our law to line it up with the state law where it was possible. That included starting accrual of sick leave on the employee's first day of work and also broadening the allowable uses of sick leave to include purposes related to domestic violence, stalking, or sexual assault. There are still some major differences, which I will highlight later, but we did amend our ordinance to line up the two laws where possible. And next slide, please. Okay, so in terms of cases, this is a recent history, and it gives you a sense of trends. You can see that the number of cases that we've opened has declined over the years, while the number of calls to our paid sick leave hotline has remained generally steady, except for the spike in calls when the state adopted its law. It wasn't a huge spike, but there was a spike there. Again, the state passed its law in 2014, and it went into effect in 2015. And while we've had a decline in cases over the years, the biggest drop is in that 14-15 period, and it was right after the state law took effect. In terms of restitution, which is the line there at the bottom, over this period, it was over $12 million to workers. Note, though, that this figure does include both sick leave and minimum wage cases as we track them together. Our cases often involve violations of both laws, and in general, if workers aren't getting the minimum wage, they're not getting sick leave either. All right, next slide, please. So I want to talk a little bit about what's working, and starting with, we have a good working relationship with our counterparts on the state level, which is the California DLSC. For example, because both the state and San Francisco laws have a posting requirement, we worked with the DLSC on a single poster for San Francisco employers. We will also coordinate on cases or refer cases to the DLSC as appropriate. Next, we fund 7 community-based organizations here to assist with outreach and education, specifically in immigrant communities, which often represent the most vulnerable workers. This outreach and education will sometimes result in a case referral to our office. And then finally, and I know we've highlighted this before, but our implementation of the CDC rule, formerly known as the 3.7 rule in early 2013, really was a game changer for our enforcement. Before this process, employees tried to remember or work to provide evidence of which days they missed due to illness during a 3-year audit period, which is, of course, really difficult. And there were many instances where employees felt compelled to come to work because they didn't have access to sick days. And then finally, there was also an increased risk of retaliation as we were relying on worker testimony for each violation. So this CDC rule methodology dealt with those issues by applying a standard number of paid sick days per year to all employees in the audit, which protects workers, and it also increased our restitution to workers. Our staff estimate a 10-fold increase in recoveries per investigation thanks to this methodology. Next slide, please. Okay, so I wanted to highlight a recent case. This is a San Francisco restaurant called Orenchi Beyond. And I wanted to highlight it because it includes blatant violations of the law, it involves retaliation, and it's also a good example of our work with our community partners. So in this case, the employer denied sick leave even when presented with a doctor's note, and the employer subsequently fired the worker for asserting her rights. That led to our investigation, and our standard practice when we receive a complaint is to investigate the entire workplace. We conducted a site visit, interviewed workers, reviewed employer records. At the end of our investigation, all workers during the audit period, which is, again, 3 years, received restitution, and also current workers had their sick leave hours restored. As to the worker who was retaliated against, she didn't want reinstatement. The back wages would have been minimal, so we worked with one of our community partners, in this case, La Raza Centro Legal, to negotiate a substantial settlement to the employee. So I highlight this case as it involves a company-wide audit with a specific instance of retaliation, and it also shows the real benefit of having community partners that we can work with. Next slide, please. Okay, so lastly, I want to talk about some of the challenges. The first is the misconception among some employers that state law overrides San Francisco law. Again, it doesn't. We're fortunate about that. Next, I mentioned previously how San Francisco amended its law to incorporate state law provisions where those provisions broaden our law's scope. However, there are areas where the two laws are still different, and these discrepancies can create some confusion. So, for example, under California law, employers may choose to provide 24 hours of sick leave at the beginning of the year, and then there's no additional accrual that year. But under San Francisco law, even if an employer chooses to front load hours, that doesn't limit how many hours the employee may accrue over the course of a year. So we get a fair amount of calls seeking clarification about how the two laws interact. That's just one example. There's a few others as well. And then finally, as a last challenge, the number of laws that our office enforces has grown over the years, which is a good challenge to have. And if we can go to the next slide, I'll illustrate that. Okay, so here's a timeline of our office, and I'm guessing there's other cities that are similar to us in that they started out with laws for city contractors and then over time added laws that apply to all employers. So for us, we started out with prevailing wage on public works projects and then added a living wage and healthcare component for all city contractors. Our first law that applied to all employers was the minimum wage, so right there in early 2004. And then you can see, if you fast forward to the past few years, we've become increasingly popular, which is a good thing, but also sometimes a challenge. We've had a healthy uptick in laws that have been assigned to our office, as you can see there. What this means for paid sick leave enforcement is that our team that enforces the paid sick leave ordinance also enforces the minimum wage, family-friendly, and the formula retail ordinances. I do want to say that while growth can present challenges, we're fortunate to have the support of the mayor and the board of supervisors. We're currently at 27 positions with 3 more pending. I'll also share that in terms of our office structure, almost everyone here is a compliance officer, and even those of us who aren't still assist with cases and compliance. Next slide, please. Okay, so that's it for me. So the first line there is our website if you want to check it out, and then the next is our webpage devoted to the paid sick leave ordinance, and then there's my contact information, and definitely please feel free to reach out. Thanks.
Thank you, Greg. We're thrilled to have you with such the depth of experience that San Francisco has, and so does New York City. So I'm going to turn it over to Ben now.
Thank you so much. It's great to be on. I want to thank everyone who's on for joining today, and obviously also Tanya and Jen for putting this together, and the other panelists. I feel like I could use up all of my time with questions, but I won't do that. So 2019 for us, actually, I can pick up right where Greg left off here. We started out the year with a pretty big change when Mayor Bill de Blasio announced that we would be becoming the New York City Department of Consumer and Worker Protection, where previously we've been operating within the New York City Department of Consumer Affairs. And this really has to do with the same issue that Greg was talking about in terms of having an expanding portfolio of laws that we're working on. If you go back to 2014, when New York City's paid sick leave law first went into effect, we were the paid sick leave division, really dedicated and focused on enforcing that single law. Over time, as we started to add other laws to what we were doing and other worker protections at the city level here in New York, the Office of Labor Policy and Standards, which had been created in 2016, was officially housed at DCA. And what this most recent change at the beginning of 2019 has really meant for us is a few things. One is, I think it's a recognition of the increasing work we're doing. In addition to paid now safe and sick leave, we also enforce New York City's Fair Workweek law for fast food and retail workers. We also administer the Freelancers and Free Act, which creates right to timely and full payment rights for independent contractors. So it's partially a recognition of the new types of things we're doing here. It also gives us a sense of permanence. We now know that for the long term, this is where we are going to be. And that's reflected not just in OLPS being here, but in an actual change to the agency name. And then finally, I think it's also just an elevation of worker issues at the city level, and a recognition that this work that we've been doing here in New York City and that other jurisdictions, some of whom we've heard about, are also doing this work around the country, and that it's having a real impact, and that city-level workers' rights enforcement is really something that New York City wants to continue investing and growing over the coming years. Now, in terms of our primary enforcement work, and I'd say that's the core activity that we do, our two major laws that generate the most volume for us are paid safe and sick leave and then fair scheduling for fast food and retail. We are starting to do hybrid cases where we're investigating both of those alongside of each other, but Fair Work Week enforcement is a very different topic and something we could dedicate another webinar or series of webinars to, so I'm going to focus on paid sick leave today. In 2019, our numbers have been relatively steady. We opened approximately 250 new investigations this year. We filed about 35 new litigations at our city's administrative tribunal and conducted 2 trials. We've closed about 160 cases. And in terms of what that's meant for workers, we recovered just a shade under $2 million. We might hit 2 million in these last couple of weeks of the year, but we're just under right now. And that would cover about 6,800 unique workers who are getting restitution, obviously in varying amounts depending on the particular enforcement action. And then we also recovered almost $400,000 in civil penalties during 2019. And these numbers are fairly steady and seem to show like a pretty linear trend in terms of how paid sick leave enforcement is working for us. And I think that's really one of the key takeaways from where we are right now, is that these laws, certainly here in New York City, are working. They are enforceable. There are certainly some challenges, some of which Greg and Alex have already mentioned, and others which I'll talk about a little bit later. But by and large, I think our experience thus far shows that these laws are worthwhile and have a meaningful impact for workers. Now, Alex spoke about preemption, so I'm not going to go into it too much, but I did just want to add a couple of thoughts to what she mentioned. Airline preemption in particular, and she spoke about the New York City example, is a pretty big issue for us. One of the distinctions I want to point out is that we have one case focusing on flight crew, which is against Delta Airlines, and then another more recent case involving American Airlines, which is actually just focused exclusively on ground crew workers. And I mention that just because I think it's important to understand that the implications for coverage here are really wide-ranging. We tend to think about airline preemption in terms of the large, recognizable names like a Delta, American, Southwest, what have you. But because these cases also deal with ground crew workers in airports performing a variety of different functions, it also implicates subcontracting arrangements and very active airline worker organizing campaigns that are going on here in New York City, and I know in other parts of the country as well. So the implications are huge. And then the other just general point I wanted to mention about preemption is that I think if you are doing this work, whether it's at the state or city level around kind of this new generation of worker protections, I think you have to be ready for and anticipating that you are going to face preemption and other legal challenges. It is just part of the playing field here. There are opposing forces who, for the same reasons that we see these as very exciting areas for innovation and new types of protections, there are people on the other side who will use whatever tools they have available to try and stop those from going into effect. So we really just view that as a cost of doing this work and embrace it. We get sued all the time. And I would just flag for other jurisdictions that it's something where, people around the country are working on these issues and I think are ready to get on the phone with you or over email, help strategize and collaborate. We've been able to do that with some of the other jurisdictions working on airline issues. So there is a community of people that can help you out, and that shouldn't be something that stops you from pursuing these types of laws. Next slide, please. Now, mainly what I wanted to focus on was just talking a little bit more in depth about two programs that we've developed here at OLPS. And the first is focused on retaliation protections for workers. And the fundamental idea behind this is that we know that workers need to know about their rights for them to be meaningful, but they also need to feel comfortable coming to a government agency and making a complaint and feel secure that if they do so, they're not going to face adverse consequences for speaking up and trying to change things in their workplace. So for us, what this really means is we kind of have to recognize that without workers, we're not going to be able as government agencies to enforce these laws. So we've put a lot of resources into trying to address retaliation issues and develop some new tools in terms of how we prioritize and enforce those. Now, what we've done here is developed a fast-track anti-retaliation model. And the key components of this, we have a dedicated team of investigators and attorneys who specialize and focus on retaliation claims. So when something comes in, it gets assigned to one of these team members who already has a depth of experience and knowledge and is going to be ready to jump right in and at least know what they should be looking for and what are some of the initial things that they're going to have to do. We're also very targeted. We do this for retaliation only. We have mandatory enforcement authority, which means at any given time, we've got hundreds of cases on our docket. We try to move everything as quickly as we can, but in terms of actually fast tracking and prioritizing, we simply can't do it everywhere. So what we do is with recent or imminent firings, we pull those out of the underlying case and treat them on a separate fast track. So if there's an underlying complaint, for example, about not being allowed to use sick leave, that will go through our regular investigative process. But the firing that may be attached to it is something that we will pull out and start working on right away. And what I mean when I talk about prioritizing and doing these as a fast track is we have developed very strict timelines for when different features of the investigative process have to be completed. So we've got a very quick turnaround for an interview with the worker, the same with talking to the employer, obtaining any documents that might be relevant to the firing. All of that has to happen very, very quickly under our protocol. Another issue that we flagged, and this is in recognition of the impact on immigrant workers, and I know Greg alluded to this in his comments, we have prepped our investigators and attorneys to make sure that they have the talking points and background knowledge and understanding so that whether they're talking to a worker or an employer, they know how to talk about immigration status and what the implications may be in a retaliation context, and also where it's inappropriate to be bringing up and where we're not going to engage with someone on that issue. And of course, it's not something that we ever directly ask a worker. And the underlying goals of this project, one is to get remedies for past harms, so whether that's back pay for a worker or reinstatement, but also to send a message to the rest of the workplace that you can feel safe coming to us and that retaliation is a real priority for our agency. And we implemented this project starting about a couple of years ago. We currently have about 10 cases going through the process. Overall, we've settled about 40 of these. Most of those have involved restitution to workers totaling about $170,000. But we have been able to get 6 workers reinstated. And reinstatement is always our priority going into a case. Again, because we think it goes both to the remedy for the worker, but also is just something that is visible within the workplace for others to see that if you do complain, even if something bad happens, you're going to be able to get back to work. And the last thing I will mention about retaliation is we had our first case go all the way through this process of starting out as a fast-track investigation and then going all the way through the litigation process. And we recently got a judgment from our tribunal for $172,000 in back pay and damages. Most of that is made up of back pay. A couple of things that were really important to us is, one, we had pled and were successful on holding one of the individual managing partners in this law firm jointly liable for the back pay. But it was also important for us to see this go all the way through the enforcement process and know that this model could work at all the different stages of a case. Now, the other, next slide, please. The other initiative I wanted to highlight is a directed enforcement initiative that we started in 2017 and for which we're just now at the stage of concluding the litigation that's come out of that. I mentioned earlier, we have mandatory enforcement authority for complaints. We also have proactive enforcement authority where we can start cases on our own initiative. And if there are any jurisdictions on the call, kind of at this point, looking at amending or thinking about setting up a law, this is definitely a point that I can't emphasize enough, that if you are able to give yourself affirmative enforcement powers, that is a particularly strong and important thing to have in your toolbox. It really gives you a whole different area of flexibility and discretion to make decisions about how you're going to prioritize and set up your enforcement. So for us, what we did in the home health aid context is this is an industry that has historically been one of the highest sources of complaints for us. There's also active organizing happening both among labor unions and worker centers here in New York City. There's other agencies that are engaged in practices in this industry with respect to wage hour and other issues. So for us, it seemed like a really good candidate for directed enforcement. And what we did is we used our proactive authority to deploy a bunch of different tools to try and get at conditions in this industry. We opened up initially about 40 investigations. Again, they weren't based on complaints, but rather our research into which industries were employing a ton of people, may have had prior wage hour or other kinds of employment violations, and initiated investigations into those employers. We were able to settle several of them, but there were a group of about 10 to 12 that we couldn't, so we started litigating those. Those results will be completed very soon. And I can certainly circulate that information to this group once it becomes official. We also referred some cases to the State Attorney General's Office for Joint Enforcement. So we're now working together with them where we are handling the paid sick leave issues that we found while they're handling wage hour issues, which are outside of our jurisdiction. And then we also used our communications with workers to develop policy recommendations that we've given to the state to try and promote better compliance in this industry. So again, I know I'm running out of time, but this is something I can't emphasize enough how important it is as an enforcement tool, the ability to make these kinds of strategic, targeted decisions about who you're going to go after to really try and impact compliance. And now that's not to say it's all easy by any means. I think for us, some of the challenges have been finding the resources to do it. We found it takes a high level of planning, training staff in new investigative techniques, and also making realistic commitments in our other areas of enforcement. So I think that's about all the time I have. I've covered a lot, so happy to take questions on any of this. But also, I think you're going to have our contact info after this. So anyone who's on who has other questions, I'm happy to follow up. So thanks very much.
Thank you, Ben. Really appreciate that. I think, the retaliation is so critical, sort of protecting workers from that, particularly right now. And I know everybody's always looking for ideas on how to do it better. And thank you for emphasizing the importance of proactive or strategic enforcement. So we have a little time for some Q&A. So I've already got some comments and questions. So I will start reading some of those out and see if our panelists who might be willing to flag those. And then I'm also going to, so please keep those coming while we do that. And I'm also going to just put up here while we're chatting everybody's email addresses if you want to contact them separately, as well as some of the tools that CLASP and CWO have been working on covering some of these same topics. So one of the questions was, if any of you can talk about the relationship to the city attorney's office and how you work with them. So I guess that would probably be for Ben or Greg.
So this is Greg. So we do work closely with our city attorney's office. We have a good relationship with them with highlighting certain cases. We have monthly check-ins with our attorneys to talk about certain cases that are needing their support. They usually get the hardest cases, of course, because we get stuck with them. I should say that within our office, we don't have dedicated city attorneys, but we do have city attorneys that are assigned to our office. So when we go to hearing, or if we ever go to court, it would be our attorneys who would be the ones who would represent us and make the case for us at the hearing or at the court level. I should say that 90+% of our cases we settle on a staff level. So again, we really just pull in our attorneys when the employer is being difficult.
This is Ben. I would echo what Greg said. We work very closely with the law department here in New York City. So they represent us when we get sued on preemption grounds. I mentioned that happens a lot. I think right now we've probably got 4 or 5 cases where they're representing us in preemption challenges. We also work very closely with them on new legislation and rulemaking. Anything that happens on that front, we're very coordinated and need to make sure that the law department is able to sign off on either something that we or one of the other stakeholders is pushing. They are not typically involved in our enforcement. Our office setup, we do have attorneys in-house. We're about 40 people here in New York City. The bulk of our staff is made up of investigators and attorneys. So when we are filing an enforcement action for paid sick leave, that's typically an OLPS attorney who's handling that case at our administrative tribunal. And I think in terms of working with the city law department, we have great relationships with the people we work with here, and I think there's a lot of genuine interest and enthusiasm about the work we're doing. But I do think it requires a certain level of educating them in terms of the larger background of worker issues, where these types of laws are coming from, particularly because they are new types of labor standards, and there tends not to be this longer history that you can look back on. So I think that's one role that we try to play that might be helpful for other people.
Great, thank you both. So the next question is relates to the Pittsburgh discussion. In Pittsburgh, although the act was upheld in July, the city still hasn't implemented the policy. And the question is, can you discuss strategies for pushing for swift implementation? So I think probably, if Alex has any thoughts from the policy perspective on what some strategies might be, and then for those of you, Greg and Ben, from the agency side, if there's anything that's helpful for agencies that you feel like you could share about, giving them the resources or ability to start implementation, what that might be.
From the policy side, I was going to say that probably the best way to look for swift implementation is to work as closely and as transparently with the agencies as possible to really get to work on regulations around the ordinance and to, build up the staff that's needed to make sure that everything can be implemented and enforced properly. That's typically, the information that we get or the information that we give in terms of from the policy side, but I'd love to hear what Greg and Ben have to say as well.
Well, I'm going to give a universal plug for resources, and that should always be part of any strategy, is having a way to push for as many resources as possible for implementation. And I agree with you, Alex. I think working closely with the agency in question is essential, and I would just add to that, starting to engage as early as possible to start those conversations. And I think, going back to what I described in terms of the evolution of OLPS here in New York City, I think it's really important to have a pretty detailed understanding of the agency you're working with, what their existing authority, areas of expertise, tools are, to make sure that you're in the right place, and also to think about how you can leverage the things that they already do most effectively.
Yeah, this is Greg. I'll just add quickly that Training's a big issue, obviously. It's great to have these sort of opportunities. And then what I found when we've talked to other cities that are starting up, sometimes it's something as basic as getting templates from our office or from CLASP or from another source, just because there's so much that goes into having an audit letter and determination, hearing request, all that kind of stuff. Just the nuts and bolts of it, I think, is really important. So maybe as we're looking at that last slide, just saying that it's great to have these organizations that can help. And certainly we as fellow cities, jurisdictions would be more than happy to help as well.
Great, thank you all. One comment that I failed to provide earlier from Dallas, which is just a really great note, is they noted that they're also sending letters to employers when they receive complaints, even though they can't enforce all aspects of the ordinance yet. So I just think that's a great idea for other jurisdictions if they have sort of a phase-in period for enforcement. It's an opportunity to let employers know that they've received a complaint and help them come into compliance with the law as employers and workers get up to speed. Okay, then I have a question around the PTO, which I know nobody is enforcing this yet. But the question is, since vacation time generally must be paid out when a worker leaves their job, is that true for PTO under these new laws that started as paid sick days? So I'll throw that out there if any of you have any insights into that.
I mean, this is Ben. I can say, at least with respect to the legislation that's pending in New York City, it does not currently require end-of-year payouts. And that's true under the existing law for paid safe and sick leave and also the amendments that would add a separate bank of paid time off.
And this is Alex. As far as I know, Nevada and Maine's laws do not require that either, but that would definitely be interesting to see if that comes out in regulations.
Yeah, and so and maybe as I'm understanding it a little differently, which is when there's a separation from employment, does the employer have to pay out unused PTO? And we were fortunate because under existing California law that the employer would have to pay out vacation or PTO when there's a separation of employment. If the employer provides it as straight sick leave, that would not need to be paid out.
Okay, thanks. I envision in a few years a whole webinar just on implementation of PTO laws potentially. But that's great, thank you all. So there's another PTO question. How do you determine what activities should be enumerated as activities that workers can take paid time off for?
So one of the ways that I know in particular Maine, well, both Maine and Nevada have been billing their PTO laws is that you can take the time for anything. They're saying, I mean, one of the, I don't want to call it one of the beauties of the law, but one of the, I think one of the attractiveness features of PTO laws is that there are no real delineated uses. It can be used for any purpose, and it's really up to the different jurisdictions to decide, the scope of what those uses really are. I hope that answers the question. I'm not sure it does.
Ben or Greg, do you want to add anything to that, or should we move on?
Yeah, so this is Ben. I would just say, I mean, under paid sick leave, paid safe and sick leave, we have tried to have, the core types of uses enumerated, though on occasion that does run us into issues about whether or not something is covered. And in the paid personal time legislation that's pending, that would effectively eliminate the just be whatever a worker wants or needs to use that time for. So from an enforcement perspective, that's appealing to us. It makes the cases a little bit easier to manage.
Great, thank you. So I have a note and a question from San Antonio. The note is that there's a hearing tomorrow, actually, on the city's motion requesting that the judge strike or enjoin only those portions of the sick and safe leave ordinance which the court finds are preempted by state law or violate the Constitution, either the U.S. or Texas's. So the judge has a couple different things like the judge could do. Sorry, I'm trying to paraphrase. Such as enjoining the ordinance until a trial on the merits, or could grant the city's request and have the ordinance go into effect without the paid component being effective. So essentially, there would be time off, but it would not be paid. So the question is, are folks aware of other laws similar to this where leave is required but not paid? So while you're thinking, I mean, I know under the Americans with Disabilities Act, for example, like unpaid leave could be a reasonable accommodation that's required. That's a little bit of a different context. So for those of you on the call, do you know of any other laws such like similar where the leave would be required but not paid? And
So we do have that in New York City under our existing paid safe and sick leave law for small employers. The threshold here is if you have fewer than 5 employees, you still need to provide safe and sick leave, but it does not have to be paid. So that, I mean, that exists in a different kind of form here. I would imagine that there are some other jurisdictions that have similar types of carve-outs for small businesses.
That's great. So I'm guessing depending on how things go, tomorrow you may get a follow-up call from San Antonio in the future.
Sure.
Okay, I'm just looking to make sure I didn't miss anybody's question, but I think we got to all the questions, unless anybody has a last-minute one. So I will just say thank you all so much for joining us and turn it over to Jen for 1 minute of closing remarks, and a huge thank you to the presenters.
Yeah, I'm just going to echo that. Thank you so much to our presenters and for all of you for joining us today. Please check out the resources on our websites and stay in touch. If you have any questions or ideas for future webinars, please let Tanya or I know, and we will be in touch in 2020 with more resources and more webinars. So happy holidays to everyone, and we'll talk to you soon.
Thanks, everyone. Bye.
Bye.
Thank you.